Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And welcome to Justicer TV. I'm Michael Bryant.
Hi, I'm Linda Kenny Patton. I'm just like sitting up where I've been. I've kind of been here all day.
Been lounging on the couch, have you?
Well, I'm on the sofa only because we've been here all day, and so it's easier for me to stretch out and put all my work here and all, as opposed to getting up, especially since it's very uncomfortable to watch very boring testimony all day sitting upright at a desk. Okay.
Well, only part of the day was really boring, and that was the second half of the first and only real witness for the day, right? And that was
Right. Well,
Ian
Whiffin.
Whiffin.
Ian
Ian Whiffin.
Was it Whiffin or Whiffle?
It's Whiffin. It's Whiffin. I remember him from Lord of the Rings and the Twin
I
Towers.
see. We're giving
Hobbit.
him a new name. We're
Yeah.
giving him a new name.
No,
Okay.
well, I call
Right.
him I think I call him Mr. Ish. That's my total nickname for him.
Well,
because
let's welcome for Loopy Hinkle, new member. Thank you for coming on. Appreciate it. And why don't we go right at what's happening here? A lot of our viewers were with us today. I mean, we had a full plate, shall we say. So, what did you learn from cell phones? That if you can't explain it and you're the prosecution witness, let me sum this up. You say there must have been some confusion in the software. That's going to be my excuse all the time. My software was confused. Whenever anyone asks me anything, my software is confused. And when things get deleted, I'm going to say, well, there must have been some system event that I can't explain, right?
Yeah,
And the third one is, I don't even know. I mean, my pencil stopped writing after he was asked tough questions about, why is this, why is that? Things that were helpful to the defense. And he had explained it by confusion of the software and system events. All right. After that, I was done with him.
I had a system event earlier today, but I took some Pepto and I'm all good now. Remember, this guy's brought on to basically anticipate and refute the defense case that's coming, because all we're talking about is the cell phones of Jen and John, who more properly might be known as Jen McCabe and Officer John O'Keefe.
Especially when you're an expert witness, you come in and you call her Jen's phone and John's phone, but Jen's phone. I mean, it's like he goes to a dinner party with her.
Yeah, until I saw the graphic where it says Jen, I just thought it was totally inappropriate. We talked about how I think the prosecution obviously okayed that. That's not the kind of thing that they're going to see and go, oh no. They went, okay, it's appropriate. It's not. So they're anticipating the defense is going to come along and talk about phone movements and texts back and forth and phone calls back and forth and butt dials and all that. And that's what they bring in Ian, Mr. Ish, to get ready to refute. So when they bring on the testimony of the defense expert saying, well, here's what happened. The phone traveled this distance, then it traveled this distance, then it went up and down 3 flights of stairs, and then it shut itself off, apparently. They can say the jury's already heard some of that in the negative by the prosecution. It just tells you, if the prosecution is so concerned about the defense case that they're putting on a rebuttal expert ahead of time, that's bad for the prosecution. They know how damning that information is going to be.
Yeah. Now, Mr. Robert Alessi started his cross-examination. It's not where I would have started. I would have started talking about the guy doing his own experimentation. He's supposedly some kind of manager in Celebrate, where he's putting his phone, like in the freezer. And I experimented and seeing when the temperature goes down. And then he's putting his phone on the dashboard, riding around, seeing if he goes up and down hills, does it record hills? And he's doing all these things to his phone. The one thing that came to mind, that if this ever went before the Supreme Court, all the things in Dahlberg Lanigan, where to make sure you had a good science on, you had reproducibility, you had error rates, you had peer review, you had all
methodology.
Yeah,
Methodology.
well, he had a methodology. I put my phone
Put
in
in
the
the
freezer.
freezer.
I
Yeah.
put
All
my
right
phone
then.
in the freezer.
And,
I
and
mean,
just because Brennan says, can you give an opinion that is within the relevant scientific community that's reliable? That doesn't anoint it as legitimate just because he uses that magic phrase. And it's an important phrase, but the underpinnings have to be there, and none of them are with the things this guy came up with. I'm just going to drive back and forth on the street. That'll help me recreate the elevation changes that are definitely not stairs. They are not stairs, no matter what you may think.
yeah, I mean,
Yeah,
now if the jury is there and then the jury wants to buy it, they're going to buy it,
that's true.
and
That's
everything that
true.
he can't do. Again, there must have been some confusion in the software, software confusion. I honestly, Michael Bryant, have never heard that as a scientific
Yep.
term dealing with Cellbrite, software confusion.
And it's important, as we've talked, he's from Cellbrite. He's not just schooled in Cellbrite. This guy gets a check from Cellbrite, which is very interesting. And I don't know that I'd be excited about how he presented their product or not, but he did. Oh, the one other thing that was interesting, all the deletions, right? Whatever the deletions were, they were definitely not a human doing them. They were not. System events, indigestion, whatever. They were not done by a human. So don't even think that they were. Okay?
Yeah. So
all of that is a setup because the defense is now going to come in and talk about all of those things, and they
Oh
won't
my
be calling
God.
them system events.
No, they're not going to call it unless he already started with his very surgical cross-examination, and he got him to admit something. He said that seconds are important here when we're talking about this. Yeah, and he's going to be off. He's going to be absolutely off with regard to it. He's going to have Karen Reed is going to have this. One thing we know is that her phone at what was it at 5:36. Hooked into was it 12:36? I'm sorry, 12:36 hooked into John O'Keefe's Wi-Fi at his house, which you drove, whether you went the right way or the wrong way. Still, it was the same distance and all. And it's not going to take 3 minutes in a snowstorm. It's just not.
Nope. And again, we'll hear from Jem McCabe soon enough, perhaps tomorrow. And I can't wait to hear her correct her 12:45 reference because she looked out the window. Yep, there's the SUV. It's 12:45.
12:45.
And we know it's virtually impossible that it was anywhere near
the
front of 34 Fairview.
Mistaken. So this gives us a very good,
Thank you, Debbie.
Debbie, thank you so much, Debbie J. 999 Nation. Thank you. So when Michael goes to Canton tomorrow, Dedham, and he gets arrested, our bail fund is continuing to grow for you, Michael Bryant. Do you think Bev, that's Judge Beverly Canoni, will restrict ARCCA to only be able to testify on rebuttal and not their original report? She certainly showed her true colors today. Disgraceful behavior is allowed today. This kind of segues us into the next witness, doesn't it?
It really does. Hey, can I throw a little sorbet in here, a little palate cleanser? Because I saw a question earlier today, and I'm not sure it's still here.
Before we get to this, we'll get to you, Debbie.
Yeah.
Don't worry.
Yeah, we are. Put a pin in that. Somebody had asked earlier today. We talked about it over the weekend because it referenced the jury view on Friday, and the question was, what's the story about The Rock? The Rock. We talked about it over the weekend.
We're not talking about the actor. We're not talking about the actor, The Rock.
We're not talking about Sean. That was my Sean Connery, The Rock. Remember that movie, The Rock? No.
Oh yeah, that's Who Killed JFK was the ending of it in a little.
Let's see if I can. Now that I've teed it up, let me see if I can find it for you. Remember, there was this mystery rock that showed up on the front lawn of 34 Fairview, and people have been asking, even beyond yesterday. They're saying, "Hey, what's the deal? What's the deal with the rock?" And we can just assume, based on I didn't live there, but I was by often enough to kind of get a sense of whether or not this rock was on the front lawn, and I think the question becomes who put it there, what was the ultimate reason for it, because clearly when I pull it up here, which I'm going to do any moment now, you're going to see that it's intended to maybe convince the jury of something or not, but why would you do this? I found it. There it is. Why would you put that on the front lawn? Unless you're trying to. It says Albert.
Yeah, but it's got a blue in the A, right?
Yeah, and then it has some other dots and things.
Yeah, I'm sure
Um,
the police didn't take it in a brown paper bag using forensically scientific methods to take DNA off it to see who did that, right? To maybe interfere with the jury, right? I'm
a-
sure that didn't happen.
and what I don't know, again, the way the cars and everything were set up, it was impossible from where I was standing to see the lawn really, because you have the SUV on the extreme, if you're looking at the house, the extreme left side of the property, right up against the bushes, and then there's the fire hydrant and then the flagpole. Uh, and so they had a cop car in front of that, meaning behind it. And you couldn't see anything along really the whole front part of the lawn, which is where the jury spent most of their time in two very separate spots. I just have to assume that was checked out. It wasn't like somebody dropped it off 32 seconds before the bus arrived. And I'm sure whoever was in the area snatched it and took it away before they got to see it. Just a guess, but who it came from, nobody seems to have a clue at this point. So anyway,
I'm
that's
sure there's
the
no
answer to
ring
that
cameras
question.
there to answer that
I
question.
think they're all broken and or
Yeah.
inverted.
Yeah,
Okay.
whatever. So let's
Okay.
go back
So
to Debbie's question,
let's go
because
back to Deb.
let's go back. This is a really good segue into. Then after that is, of course, we were all waiting for ARCCA, right? And we did have a first witness in ARCCA, and that was.
Yes, that was really Wolf, and we're going to get to that video. Let's just make sure we point out to folks that Alessi did not finish his cross-examination of Mr. Ish, who I call Mr. Ish because he guesstimated it. And he said, I think that came in at 12:32-ish. Well, thank God we have an expert who can tell us that. So anyway, Alessi will continue. I'm assuming tomorrow before Jen McCabe comes on. That's all my assumption at this point. So let's get into what happened today, when really the important part of the case unfolded outside the presence of the jury. Dr. Wolf, Dr. Daniel Wolf with an E, part of the ARCCA group of 49 different experts we learned today in class. Check this out. Is it my imagination, or is Bev eyeballing this guy from the very start? I mean, Judge Cannoni. Look at her. Look at her.
You solemnly swear the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
Daddy.
She's giving him the side eye.
Daddy. 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 Daddy.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Oh, wait, I got the
Daniel
wrong
Michael
one.
Wolf,
You know what
last
I got?
name spelled W-O-L-F-E.
This is actually from
Dr.
his
Wolf,
first testimony.
what do you
I have
do
the
for a
wrong
living?
one.
I am the Director of Accident Reconstruction at a company known as
that kinda
ARCCA, A-R-C-C-A.
And what is ARCCA exactly?
So ARCCA is a
Okay.
This is
well,
actually the wrong testimony. This is
no,
the
this is from the last trial, first
from the,
trial.
from the
Yeah.
first trial, yeah, but this wasn't
I
today's
grabbed the wrong one.
testimony. Yeah, this wasn't today's testimony. So
No, it's not today's
let
testimony.
me while you're looking for that,
Let me
because
see if I can find that.
it's something that we talked about doing, but we decided not to do it because this was the motion. Remember, the judges already found the defense in 2 Rule 14 violations, and those discovery violations. Today was supposed to be a hearing on the second one. She gives him a hearing after she finds him in violation of Rule 14. She has this order that, all these things that he's got to bring, and so they spent all this time doing that, and he sends them to Miss Little. Hank Brennan has a conniption because it wasn't sent directly to the court, and Hank Brennan decided to cross-examine his best Wicked Witch of the West cross-examination, showing us his real true colors. Now, if you were doing this as a defense attorney, right, pretty good, right? But you're doing this to try to get to the truth, and you're going to see some stuff. And could she, you and I, matter of fact, talked about that maybe she's going to limit because of the issue of the talking to the FBI in the middle of his testimony. But he wasn't sequestered because, no one told him he was sequestered. He couldn't talk to the DOJ who hired him in the middle of the testimony. No one told him that. And so the question becomes, because of that, and since this turned into not a Rule 14, but something else, is she going to then say, you can't come in and talk about your main report, but you can only rebut the report of the Commonwealth, who, by the way, is rebutting the report of you. So I don't see how she does that.
Yeah, I thought it was kind of, really
But could she?
inappropriate of Hank. Oh, could she? Oh, well, she can do anything.
She can do it. She can do anything she wants.
She can do anything she wants. The only question becomes, what's the impact after the fact? Hopefully, if there's an appeal, you're going to have a stack of appellate grounds. If there's no conviction, then all of these things become, who cares? But as you're moving through the trial preparation and presentation, they're huge. They're big issues. I just thought it was for Brennan to focus on the sequestration thing when he knew damn well that at the time he's trying to suggest to the court, and she doesn't need much suggestion.
And
She's
people
trained in
and the
that way.
audience.
And the audience,
big audience.
maybe, but the
Right.
only audience that matters is this judge, because she's going to decide what, if any, testimony is going to be allowed by these witnesses. But to suggest, oh, well, they violated the sequestration order because the defense didn't tell them about it, which would have been inappropriate for the defense to tell them about it because they weren't working for the defense.
Right.
So by laying it out that way, he's making it sound like he's jumping over that hurdle. He's making it sound like, well, of course they were working for the defense. Therefore, not telling them about the sequestration order is once again reason for grave concern about what the defense did or didn't do in this case.
Yeah. So could she do it? Well, she's definitely not going to let them say the DOJ, and that explains everything. I mean, I don't know what the bug she has, not saying that he works for the DOJ in a matter you don't have to be concerned about, but you're going to hear that in doing that, he evaluated this. I mean, they could think, the jury, quite frankly, could think it was to convict Karen Reed, right?
Sure. And I thought, when the jury in the first round thought that these folks were from her insurance company, that's not a horrible speculation. Obviously somebody on that jury had some interaction with insurance companies, knowing that they have investigators, right? You have an accident and they're trying to figure out, I had a case once, 10 vehicles involved. That is a cluster, beep, because then you've got 10 different insurance companies and they're all fighting over who's really at fault, right? And how to apportion it. And how do you do that? Well, quite often you do it with an accident reconstructionist. So it wasn't that weird for the jury to think that, but it's so ridiculous for them to have to fill in that blank. Just tell them.
Right. Just tell them.
Tell them.
Right. And if Hank is going to say, well, you can't testify because you talked to the DOJ, that's who hired them. And if the DOJ wants to talk to them in the middle of testimony, they're not a party to this action. So what?
Yeah. And so there was the interesting, part about what was asked for from the court. The court said you need to bring this stuff. Right. Well, then Brandon's trying to make a big deal out of the fact that the expert didn't give it directly to the court. So talk about that for a second while I'm queuing this up.
Okay. Well, let me answer this question while you can. From Touche, great handle. Thank you again for the donation. They must love you, Michael. They must want to make sure you don't get, when you get arrested, you have bail. Okay. Yeah, I've concluded that the times we finally see Judge Canoni lose her patience with Brennan is when she's given him all the help and he's still wasted. Yeah, we did see that at the very end. She clearly told. She was pushing actually Leslie along, like, we're going to get to Rentschler, and Leslie wasn't being pushed. And then finally, when there was redirect, she kind of said, that's it. I want to see everybody at Sidebahhh. They after 4 o'clock, they went and they called Dr. Rentschler, and she gave him 4 questions. Hank Brennan said, that's it. You're done that's it. You're done. That's it. We're out of here. So,
I mean, nothing says I've already made up my mind like that kind of truncating of a witness. She already knows what she's going to do,
Right. And maybe she's done it. Maybe she's done it,
Yeah, that's right. We're still kind of waiting for some sort of decision, right?
Yeah, because she said to them, could they have the report done? They said May 7th, which is like a week, right? And she wants it done beforehand. Wednesday. She's going to order them 2 days. You have to have it reported. You can see it by Friday. You can see it. You can see it coming.
Yeah, no, it'll be very interesting if, in fact, it does. This one I don't want to play because I think I just did that one before, so let's not do that. Bear with me. I'm getting so much closer to this testimony. And we're going to focus, and you'll see why if you missed some of this today. We're going to focus primarily on the interaction between Mr. Brennan and Dr. Wolf. And you'll see how he gets so testy and really
nasty.
Who was he performing for? Well, the judge. We know that, right?
I think the judge. I think he's also performing for the public at large because he wants to say that suggests you look at how terrible the defense is, right? They're underhanded. They're evil. You got me doing it now.
Forensic engineering.
I'm afraid I got the wrong one again, so I'm afraid to put up. Oh, there we go. There's the right one. Okay. There we go. There's the fan. We'll skip past the fan unless somebody wants to see the fan.
Well, that's Mr. Ian. System.
Oh God, I hope I got more than Mr. Ian on here. Okay, here we go.
No comments, please.
Oh yeah, she did chastise him occasionally for comments. When he would Brennan would react to one of his answers that he felt was maybe a non-answer, right?
But he felt everything was a non-answer because he just wanted to try to make him look bad.
Previously, about a month or so ago, maybe longer, I found that there was a violation
Breathy.
of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to
Deliberate before you had a
compel
hearing.
reciprocal discovery
Which
of the
this is
ARCCA
the
witnesses
hearing.
or to exclude their testimonies. Upon that, I believe, I issued an order last week for certain discovery to be provided and to be provided by ARCCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll
think?
have to have them back.
I don't
but
see how you
expect
have a
we can get through
hearing
them.
on
So,
something you
Mr.
already
Brennan,
found, but that's
who are
beside
we
me.
going-
Due process does not exist when you have the hearing after you found the violation. It's like Alice in Wonderland.
She just, yeah, that's right. She found it with her own little
That the
rules.
testimony you shall give to the court in the matter now in hearing shall be the
Okay.
truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
All right, go right ahead, Mr.
Thank you.
Brennan.
Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So we
order?
need Dr. Wolf to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolf, last name spelled Wolfe.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Miss Little last year, I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Miss Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson
Yes, sir.
a number of times.
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
He's like,
I
you
understood
know
him
what
to
he's
be the
like? Can
defense
we
attorney
stop
in the
it a
case,
second,
yes.
Michael?
Did you speak to
Stop
Miss
it a
Little,
second.
Michael?
Hold
Let's
on.
try
I
it
don't
again.
believe so, no.
Stop it. He is like, he's taken lessons. Maybe they go to prosecutor school together when they were a prosecutor. He's like Lewin. Let me try it again. You don't get the answer. You get the truthful answer, but it's not what you want.
No.
Because you want to make him say it again. So maybe he can get some kind of
Listen to my
something.
question.
Yeah, listen to my question. Now
That-
let me ask. His is let me ask it again.
Uh-oh. Yes. Okay, here we go.
No.
Did you speak to anybody
Hold
but
on 1 second, please. Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Ms. Little and Mr. Alessi.
Okay, and how about Miss Reed?
No, sir.
You know, he
Did
asked
you
about
ever
Miss
have any
Reed twice.
conversations that weren't on
What's
a
that?
regular telephone? You have a Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
Actually, I mean, this is where the judge should have
So,
stepped in
Are
constantly.
you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned,
Did
again,
one.
the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Of course you are.
Oh,
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well,
'Cause
what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
So it's important here to set up what he's going for and what we believe is what happened. In March, they reach out to one another and there's a contact, and it's this conversation where it's, well, how do we do this? And what can we do and what can't we do? And part of that conversation, this witness, Dr. Wolf, tells Alan Jackson, well, here's how we do things if it should happen. You know, it was that kind of conversation. We're not sure what we can do, but if it should happen, here's how we normally do things. Retainer
Right.
agreement, blah, blah, blah. So every time Brennan is asked, he's hoping for some sort of more underhanded kind of, evil intent that, well,
Right,
we
that-
knew
right.
we were going to do this, but we didn't want to tell anybody yet.
And that's what the judge was. That's what the judge, I think, has hated Alan Jackson all of a sudden since when she learned there was a bill that was sent afterwards. She figured that there was some kind of underhanded thing going on. But what came out today, and I think what she's got to be worried about, you know what came out today? The federal government has been watching their witnesses. They watched the first trial. They wanted to give them even more information. And I will guarantee you that they are now watching this. And I
Sure.
think
Oh,
Judge
yeah.
Beverly Cannoni has a lot to deal with and think about. If she thinks she's going to impugn, impede, hurt, diminish, or demean these witnesses who are working for the federal government, because the feds don't take that kind of shit lightly. And one other thing, Michael, before we go on, Dr. Wolf was such a gentleman, I think, on the stand. We learned that much to the chagrin of his family, when he testified at the first trial, because of things said in the courtroom, okay, now I wonder who said things in the courtroom, his whole family was intimidated. His kids' pictures were doxxed all over the internet. He was worried about his family. That's witness intimidation. So if you don't think the feds aren't watching this closely and clearly now, and watching Hank Brennan, who represented Whitey Bulger now, boy, are we in for it. Was Judge Beverly Cannoni going to be in for a surprise?
Yep, and it could hit very close to
I'm
home.
not asking what you determine later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you. On March 20th, 2022, not the 22nd, not the 24th, March 20th, 2024, did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
He kind of misspoke there. He should have said prospective
And
client.
so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
the end of April, how was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Boom.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring to?
Do you remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes. Specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Well, sir, you said that that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCCA.
Well, this is a new relationship, right? You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April still?
Yeah, we're still talking at April. April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
You see, this is just you know, he gets the answer with the truth, right? And he doesn't like it. So then that doesn't take more than one call to try to intimate that something's going on. So Debbie J wants to know, and thank you, Debbie, for being such a supporter to Justice Serve TV. Can the government do anything to intercede on behalf of ARCCA with the judge? Well, they probably won't. But you know what? Sometimes things come around and they hear things. But I think more importantly, she has to know that they're watching this. They're watching her treatment of their witnesses who they may want to use in other cases. And in fact, after watching today, you know, that investigation could get reopened, couldn't it? Because, right? Think about that.
Yeah. So Debbie's right. I mean, everybody's so frustrated seeing this unfold. They're like, somebody has to be able to do something, but it's more an after the fact remedy. You know, it's not like, you know, the feds are going to storm the courthouse and courtroom and rip Judge C off the bench, although that's what we would kind of like to see at times. No, but if she's doing something inappropriate, then yeah, there could be repercussions. We'll just it just ain't going to happen today. It's not going to be that satisfying. I was going to say something else about what he was going after here. He's every question tries to intimate inappropriate contact between the defense and ARCCA experts before. Again, remember, we're talking about May 1, which is basically 2 weeks into trial, May 1 of 2024. Right. And he has a 40-minute conversation at that time with Mr. Jackson. And ultimately, it's billed. And this is where I think it gets a little slippery, and the appearance of impropriety is probably worse than reality, because I think it's an administrative thing. This guy is not Dr. Daniel ARCCA Wolf. He's one of 49 experts who are all just, they're all just filling out their time sheets, just, like an attorney in a firm does. 0.2 hours, spoke to Alan Jackson, Ray, method we use to set up a retainer agreement, something, and then they turn those in. And then somebody decides, okay, now it's time to bill. Now we send out the bill. I think it creates this illusion that, oh, hey, wait a minute, you had this 40-minute call May 1st, right? The smack in the middle of the first trial, and you billed for that. Why would you bill Alan Jackson for that if you were not discussing the case?
But he didn't. He billed under, it's going to come out under the federal number. He
Of
didn't even know.
course.
He didn't even know that ARCCA, which is a big firm that's there to make money, billed the time, because they
That's
want to
what
say,
I'm
hey,
talking about.
they look back and they say, hey, this guy was testifying. Somebody's got to pay. If it's not the Fed, it's got to pay. By the way, Charles Argo donated money to you also. Confession through projection, Brennan.
He's definitely a projector. And when somebody like Brennan has done so many shifty looking things, it just seems normal for him to accuse others of doing shifty looking things. That's typical projection. Okay, let's see if he gets any.
May have been in
nastier.
court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
What the hell?
Sir, that is my best guess. I don't recall from a year ago.
First of all, those numbers are probably rounded up. So if it says a 2-minute call to the main line and a 3-minute call, it's probably 1 minute and 2 minutes. And as it clicks past the first, it just rounds up. And how many times have you called a big company and they put you on hold while they're looking for somebody?
Yeah, right. I mean,
It's just so stupid. What do you think could be done in a minute or 2 minutes of any substance, right?
And are you just making that up?
You're just making that up.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
Did he
You're
say
making a
secretary?
representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Okay. Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCCA, but never ever talked about this case?
Objection, Your Honor.
I'm going to allow it.
Correct.
Sure.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes, I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can we approach, please?
Who asked me that?
Me, Your Honor.
Yes, come on over.
Wake up, Judge. So, you know, this back and forth is such a time waster, and nothing's going to change. The guy's made it very clear. Those calls with which he remembers anything of substance, it was to talk about their process and what's going to happen going forward if they get retained. No, I didn't talk about the substance. I mean, ultimately, it comes down to credibility. You know, there's no recorded sentence or recorded phone calls. So either Judge C believes this guy or she doesn't.
Well, let me tell you, if she doesn't believe him and makes statements to try to affect his credibility with the Department of Justice, I think there's going to be big repercussions. You know, okay? I think there's going to be absolutely big repercussions. It's outrageous what she's allowing Hank Brennan actually to do and badger him, quite frankly. And it's so beyond of what this hearing was for. And after the fact hearing, where she's already found a violation by the defense team, when there's clearly been no violation, when you listen to him, clearly none.
No, it's just her perception and, you know, bias that pushes her in that direction. So they have a little Sidebahhh here, and as we've said before, everybody goes up.
All of that time was actually tracked under
bench, including
the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Okay. Now, when you billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCCA, talking about your families?
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay.
Objection, Your Honor.
No comments, please.
Just a little
Do you
snide
typically
comment.
charge
What a-
when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
Oh my God.
It's no
I
Jen
guess
and
first
John.
name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
I talked to him like I talk to all of the attorneys that I work with, sir.
What would you call me if you were
Dick.
going to address me?
Probably Mr. Brennan.
Because I'm not working with you, asshole.
It ain't
Excuse
ever
me.
happening.
Do you remember the next time you spoke to Alan?
Really?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here. I just don't have a habit of keeping that type of text.
So
he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
He told him.
Okay.
He told him.
How many texts did you delete?
Stop it, Michael. Let me
Communications
just
with
stop it right
defense.
here because I want to go on a little mini rant. Okay, we have in this case, we have Brian Higgins who takes his cell phone, she's an ATF agent, takes it to an army base, takes out the SIM card, destroys the phone. We have the Alperts getting rid of the phone. We have Jen McCabe getting rid of the phone. We have Kerry Roberts, right, getting rid of a phone, if I recall, right? We have all these people to get rid of phones, getting rid of text, and yet this guy comes in. He's stalwart. He's by an independent firm. He's hired by the DOJ, and Hank Brennan is going up there. He didn't give a text to you. He didn't give a text. I'm just beside myself with the rudeness that you cannot be a witness in a high-profile case and get treated with any type of respect. It's outrageous, and even Domino agrees with me.
Domino is not happy about it. Yeah, and and I don't know if it's bad hearing or just he's trying to be a jerk about it, but he clearly said, I deleted the text. I do it all the time by rote. I just do it. And then when he circles back to it, so you're saying in this case, you did or you did not? I think I told you I deleted text. Well, you didn't, but now you have. I mean, the jury should see this guy in his full
I'm
flavor,
putting it right now. I delete texts all the time. I've got freed up my phone. I don't want to be going down and seeing all these text messages that are old people I don't care about. And when you delete, it's not that you delete. When you just delete the whole text thread, right? Delete. Goodbye. See you. I mean, it's something I don't need to clutter my life with.
Yes, I understand.
I don't know the number, sir.
You don't know the number?
Is it 100?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was there 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
Isn't it 96?
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial, sir.
Where were you when you were deleting these texts? Were you at your office, at home? Do you remember sitting down in deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts where you
Sir,
were?
I just said I delete text routinely. You're asking me to specifically give you a location and a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, it's an encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
He just said,
No,
Alan
again,
Jackson
I think it was
said.
Mr. Jackson that said it was his preferred method.
Is that standard in your industry to
You don't
use
want
Signal
people
when you're
breaking
talking
into
to
their
clients?
phones.
I don't know that there's a standard out
You
there,
don't want
sir.
people
asking about your
stealing
standard.
off your phones.
Is it your standard to use an encrypted app when you're talking to?
The Facebook Messenger's encrypted also.
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations did you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible, so we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know. How many times did you
No
use
thinking.
Signal with
No
the
thinking
defense
zone.
to talk about this case?
The answer without thinking.
Going to allow it.
From what I recall, was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right, I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means.
Probably
what that
around,
means.
probably 4 to 5.
How about
Well,
one?
four or was
Maybe
it
one
five?
time? Oh, I'm sorry.
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on
Right.
Signal? The 4 to 5
Uh-oh.
times.
Linda's down.
I
Linda's
think they were
down.
pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Were you
yes.
putting it on a timer? Each one had to be
down,
a maximum
hold
of
on.
5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
That's the best answer I can give you,
Michael
sir. I'm giving you
Bryan
my
is
best
trying to kill
estimate.
me
I'm asking you
by
how confident
showing
you
me the third
Answer that. How
finger
confident are you, Dr. Watt?
testimony.
I can't answer
I'm
that
sorry,
anymore.
what I've
When
been.
you're required
Think of
by
my
court order,
notice.
Are you gonna be all right?
I
Okay.
started laughing so hard that I'm sure I'm choking to death. Okay.
Okay.
to provide all
least
of
I'm
the
doing it in
records
my
to your
Just
honor,
Serve
you
TV
knew
mug.
that one of the important things you need to respond to were communications between you and the defense for her honor to consider, right?
Yes,
And Signal is a communication, isn't it?
certainly.
You looked at all your records and knew it listed the text messages and the phone calls. You knew that, right?
Yes,
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked, You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes.
Okay. And you never informed in your response that there were phone calls through Signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon
Record.
entries
That's
as well as the
records.
emails. I could not, there's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Have
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
During those 4 to 5 Signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these Signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the costs of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill. I'm not.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a
Oh,
pretty
God.
particular name. So when you use words like you believe, you know. You know. So did you meet a person by the name of Kat?
I'll allow it.
The mysterious cat.
I think when I arrived here, yes.
Well, without the qualification, the simple question is you've met Kat, haven't you?
I think I met her, it was either at the voir dire day or the trial day, yes.
Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
What escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street, and I think she walked me over, and then ultimately when I was done, I think she walked me back to the lot.
Did you have conversations with anybody for the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
Well, I'm asking if you've met them, not whether you walked in together.
Oy.
I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
I'm going to allow it.
It's a pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face,
Yes.
right? Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would be needed. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. And I could certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there, but there's a lot more communications before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
Okay. You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
I see. Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
Well, so you check in with the client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report
Yeah.
of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
You get the feeling Dr. Wolf was kind of amused by Mr. Brennan. You know, he takes his job seriously, but he thinks this guy's a joke.
Showing you an email, do you recognize that?
Yes.
From you to who?
To Mr. Jackson.
Okay. And what's it labeled as?
Wolf Direct.
And that's before you testified on trial 24?
It's at 6 p.m. the night before I testified, yes.
So it's before you testified?
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
Okay. You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers for him to ask you when you testified?
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Can I take that, please? There's an email with a document I'd like to attach this as an exhibit.
Okay. Exhibit 1.
Now, this is the part that I
One.
think gets a little interesting. And this is the part where he sends his report with these notes about the things
So
he might
you
want to talk about or
assisted
not.
the defense before your testimony.
Hold on.
Where's the one with the comments?
To Alan Jackson, suggesting direct testimony questions. Again, this is before the first trial.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question is,
Hold the comments, please.
my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Sustained.
Do you want to answer my question, or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no comments, please.
Do you think that providing a direct examination to the defense before you testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Objection, Your Honor.
Sustained.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense and you gave me a response that this is something typical, but it's just an outline, you wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
Objection, Your
I'm
Honor.
going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked of, if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here, under oath, before this court, that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said, not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
Sir, there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination,
Yes, slow down.
sorry, when you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles, who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspect the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions. Ask one question.
Oh,
You
don't
wrote,
talk
I
about
have a
your
feeling
phone.
they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Finally, at
Did
least
you
somebody-
write that?
Yes.
And the judge doesn't
And when
do
you said
anything.
they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right. And you offer an explanation or a way to deal with what the Commonwealth may confront you with, don't you? You make a suggestion to help the defense, don't you?
Again, it was to help the jury understand that because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury.
Yeah.
That's what I was trying to make sure that that point was understood, to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would
I
you?
have to lower my sound because my drums are going.
I don't know if I understand your
Okay,
question.
you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. You remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
And then, do you defer to the defense, not the jury, trying to give the full story to the jury, do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it, and then you can give any explanation you want.
Hold on. Next question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because, for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions. 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to...
Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not, correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
Finally, we have a move along, okay?
And that's because she already knows what she wants to do.
I don't know about you, but I've really had
As
enough.
you sit
I mean,
here
I-
today,
this
you
is the
don't
second
really
time
know
I've
how
watched
many
it.
communications you had with the defense before your last testimony, do you?
For trial one,
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls, incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed, at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was
And-
no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCCA did send an invoice afterwards, yes.
Did you talk to ARCCA about that? About the billing in this case?
No.
You submitted your bill. Yes?
ARCCA submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement, and ultimately he's also an accident reconstructionist, so it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me the report is a general report that has yours, Dr. Rentschler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it, yes.
It doesn't distinguish who did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easier to understand if you could just tell us what the conversation was. That's what I'm asking you about.
Objection, Your Honor.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, again, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire and the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
No, sir.
Did you ever see anybody's testimony at any time during the first trial?
I might have seen a few news clips, but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And, sir, is there any other communications that you've had with the defense that you didn't tell us about outside the text and the phone calls and the signal calls? Or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
Oh, thank God. Okay.
I mean, this was like
Well,
torture.
I
sitting
think
through this
I'm done
discussion.
with everything that I've got to ask. Get my file organized here.
You know, but the problem is that the judge let it happen, right? Because she
encouraged it.
Well, she's also looking for something, and
Sure
I
she
don't think Wolf gave it to her. I don't think Wolf gave it to her.
You know, again, she probably thinks she has enough to go wherever she wants to go. If that means limiting the testimony to what we heard in the first trial, not identifying the source of the first investigation, the feds, she can make that decision. Going further than that, to leave them out of the trial completely, that could be tough. But she's going to focus on that one little exchange with the report and the notes suggesting this might be something to talk about. This might be something you want to avoid. That sounds a little bit like you're working for the folks. I'm being honest about it. It's not as squeaky clean as I would like.
It certainly raises the question about whether or not they thought Well, you know what? They found that there's no collision by the car. So they do, and they're not contacted by the prosecution. So the prosecution knows they're not going to help them. The defense is going to be supporting their work, and they want to have their work out there and supported, right? And this is a good example, though, of this is kind of like a threat by Hank Brennan. You're going to come here, and this is what you're going to get. I'm going to embarrass you on national TV in front of that jury. And you think your relationship with the feds, you want to talk about your relationship with the DOJ? Well, I'm gonna give them something to think about. I always call these like threats. The same with Dr. Marie Russell, like in the cross. This is what you're
That's
gonna
right.
get. This is kind of like a threat. I mean,
Yeah.
I just think it's a shitty way to handle honest experts.
It is. And to contrast those two experts, Dr. Russell, I felt sorry for because, she's like, I'm an ER doc and I'm just here. She reached out to the defense and said, I think I can help. But when she was on the stand for 2 days during the hearing, the Dalbert hearing, it's like she was beaten. She was beaten, right? And I think it affected her far differently than Dr. Wolf. Dr. Wolf was just like, this guy's an idiot. He's just a goofball. His life is not going to change based on this examination or any examination at the time of trial. So Brennan did not win this round.
Yeah, and it's clear you just added somebody, another accident reconstructionist, like for an internal peer review. But this is the guy on the probably you looked at. You said the ARCCA does it by alphabetical order, but he's probably, in terms of the depth chart, he's probably up on top of the list if he's assigned to work on a case for the DOJ.
Yeah, you would think. They got 49 quote experts, but yeah, somebody's got to be the top dog or close to it. So, and again, the difference between Dr. Rentschler, the biomechanical expert, and Mr. Wolf, Dr. Wolf, the accident reconstructionist, they have some overlapping issues, but they're very specific in what they are experts about. So that's why those two are in there. You don't need two accident reconstructionists. Brendan's trying to make it sound like, well, to get to the determination that you don't need a second accident reconstructionist, you must have talked about the case. I don't think that's necessarily true.
It's not necessarily what we do. I mean, I make a decision. I don't talk about to an expert about why I'm not calling the other one.
Why do we need two? We don't.
Why do we need two? I mean,
you're the best one,
right? And you're the best, right?
I have a faint recollection, and somebody may have chatted about it, that Judge C was trying to limit bodies, right? So I'm not so sure it was ever even possible to have three.
Yeah. I'll tell you what, the feds aren't going to want to give Judge Beverly Cannoni any documents unless they're going to help their experts, because they're, as I said, if they were watching the first trial, they just saw this. And they already, Hank Brennan has lost the DOJ. So, it'd be interesting to see if all of a sudden, pursuant to any TUI request, the feds say, okay, we're going to release some more stuff. That's not going to be helpful. It
will not be helpful. That's for sure. Well,
we're going to see what happens. Be helpful, but it's going to be helpful to the defense. It ain't going to be helpful to the prosecution. It's not going to be helpful to Hank Brennan, that's for sure.
So we may get a decision first thing in the morning, or maybe something in the middle of the night. Who knows?
Yeah, who knows?
Judge C gets up for a refreshing beverage and decides to scrawl on a piece of paper, as she likes to do. Who knows? And then so tomorrow I'm on the road.
Well, you almost killed me tonight. You almost maybe killed me by laughter. I choked as I was taking a sip.
I was just counting. When he said a handful, I was just counting off how many things are in a handful. You got to start with one, and then there's two, and
and that one finger just happened to go up. And
one finger, I can't tell which order I'm going to count. It's the tallest finger. Anyway,
watch the murder in real time.
So tomorrow we'll circle back, and midday I'll be up there for sure by then, and maybe again if they finish the Mr. Ish cross-examination, then Jen McCabe may be the afternoon witness. I don't know.
I call him Whiffle. I know his name is Whiffin, but I'm calling him
Whiffin. It is definitely Whiffin from the land of
like the stuff that goes through Mr. Whiffle.
I just learned about the wiffle ball the other day, and I should know this. Not far from here in Connecticut, they created the wiffle ball.
Yeah,
and it's a factory there. They're still the only place in the world that they make the wiffle ball.
I don't know who uses the wiffle ball anymore, but Debbie J, thank you. A rumor is Jen McCabe is testifying tomorrow. Yeah, she is. Yeah. She's on the list for after Mr. Whiffle Whiffin, I mean, I'm
Mr.
laughing. Mr.
Whiffin.
Whiffin testifies, but
From the
he's
land
going
of
to take,
hobbits.
I assume he's going to take pretty much all the morning, and I assume her direct is going to take the rest of the day, and then the real fireworks would be when we get to the cross examination. But thank you,
Oh my
Debbie J.
gosh.
But what we plan to do is we're going to be streaming. I'll probably hop on, I'll be listening to it, but I probably, because I have some other things, we'll probably hop on at the 11-ish break to discuss with you all what's happening. But you got to stream here for me to be able to talk to you, and then Michael will get up there and be set, and he'll certainly be ready for the 1 o'clock lunch break,
Yep.
1 to lunch break, and then he'll be watching with you all, and I run and do an appointment and be back for the end of the day, and then we'll have our 6 o'clock wrap up show also tomorrow night.
Yeah,
So
from
that's the plan.
some location. I don't know, maybe by the courthouse, because once it clears out, it's easy and it's actually a pretty good location. So,
Yeah, please don't get arrested.
yeah.
I understand that there were some other
you're
briefs.
disappointed the first
No, I
time
know.
that
I
I was not
understand that.
arrested, and
I'm looking at your lawyer, and I think that some other big time briefs were filed in support of the the reduction of the buffer zone. So
yeah,
I'll let you deal with that.
they had a briefing schedule, so
Yeah,
that's
yeah.
continuing to chug along. So
Yeah,
nothing new.
unless he's still at bat, right? We're going to see Alessi tomorrow. He's still at bat. He's doing the forensic analysis, and he's very meticulous about it, as we see.
Yes, he is.
Yes,
So
he definitely.
all
is.
right. So
Okay,
I
all.
guess we'll see you then. Michael Bryant here, try to do the right thing.
Before you go, though, there's so many people watching. You have to hit that like button, please. Hit that like button, okay? Going to give you a chance to hit that like button, and then the share, the subscribe, and the notify. And remember, that's all free. I mean, so please do that. Gets us into the algorithm, makes the channel grow. But hit the like button. And I'm Linda Kenny Bodden, and with Michael Bryant again. Yes, we will see you tomorrow.
From the sky.